And welcome to the Week 9, Chapter 9 video lecture. In this lecture, we're going to talk about defendants, victims, and witnesses. Now, we've talked about the courtroom work group, and now we're going to talk about the people who come into court and are involved in the case in some way, some meaningful way. Okay, it could either be through a witness appearance, could be the victim of the crime, or it could be the defendant themselves. Either way, we're going to look at those people in particular. Let's look at the learning objectives. First, we're going to list 3 characteristics of defendants, and we'll see that some of them are kind of distressing, especially the minority status of so many of them. We're also going to describe how victims and witnesses view the court process. We're then going to describe how court actors view victims and witnesses. So the court actors, of course, are the judge, the prosecutor, and the defense attorney. Sometimes a probation officer also. And so we're going to see how those people now view these victims and witnesses, because, by the way, they see them every day. I mean, there's another case, you get new victims, new witnesses, new defendants, everybody else. Next is we're going to discuss the prior relationships between defendants and victims and why this is important in domestic violence cases. We're going to see that there are often relationships between defendants and victims. And very often, the victim in our case today will become our defendant in our case tomorrow, in my experience, and in many people's experience in the criminal justice system. It is just the strangest thing to see that you might be helping out a victim in a case where they were, beaten up in a domestic violence situation, and the next thing you know, they're out there in a big embezzlement case, or perhaps they're involved in selling drugs, or who knows what it is. And that same victim now becomes a defendant you have to prosecute. All right, we're also going to identify 3 types of programs that are designed to aid victims and witnesses in coping with the criminal justice system. We'll see that there's been a great movement to help victims and witnesses in the criminal justice process, because before they were basically left out in the cold. A witness could end up getting killed because they had a witness appearance and said something that someone didn't like. Victims, of course, there's nothing to help them. Most of them couldn't afford a lawyer to go after anybody to sue them for their damages, and even if they did, there wouldn't be any money there to get. And so they were basically left, in disastrous situations. Next, we're going to explain why some view victim programs as aiding victims, whereas others view these programs as manipulating victims. Because if you think about it, there are victim programs that aid the victims, that give them services. For instance, they'll give them medical service. They'll pay for their medical bills from the crime. They'll pay for their psychological counseling bills. They may pay for some other benefits of one sort or another paid upon the state. But what that does is it might make it so that we can say, hey, wait a minute, we've got victims now who are sort of feeling like, if I don't do what the prosecutor wants, I may not get this aid that I'm so desperately in need of, especially if the medical services are needed for an extended period of time, or the psychological services and so on. This could also be for their children, who might also be victims of crime. So, yes, they do aid victims, but there's also a potentially sinister side to it, because it may make them want to do something that they shouldn't, which is to say something in their testimony that didn't happen, or color their testimony favorable to the prosecution when they shouldn't. All right, let's look at some of the characteristics of defendants, because you're going to see that these are distressing, as you might imagine. First of all, the most important, now we're talking about felony defendants, not necessarily misdemeanors, but felony defendants. First, they're significantly younger. In fact, most studies, criminological studies, will tell you that there's sort of a way of aging out of crime. After you get into your late 30s, the percentage of people who are felony defendants starts to drop precipitously. It's as if they figure that it's just not worth their time anymore to be out there doing these felony crimes, getting hit all the time. Younger people, not that way necessarily. So you're going to see significantly younger people, overwhelmingly male, absolutely. And many of the crimes are theft crimes, drug selling crimes, things where people are trying to make money. And so we'll see that if we go down here at the second to last of these, more likely to be unemployed, very much true, because they're out stealing things because they feel like that is a way to be able to make money, and they're not able, so they think, to make money, at least not easily that way, of the normal employed person. Also less likely to be married, as you might imagine as well. Less educated, which of course brings in fewer opportunities in the employment range for these people, which might also give them a reason for wanting to go out and commit the crimes. But the part that's really, really terrible in the sense that we can't quite understand it, we can't explain it, we don't like it, and that's that there's disproportional racial minorities in the felony defendants. I mean, it's a serious disproportionate. Something like 3 times the number of black defendants based on population in the country versus whites. So they may be, let's say, 30% of felony defendants are black, and there's only 10% of the population. That would not be an unusual statistic at all. White people who may be, you may say they're 70% of the population, let's say, we're only looking at 10% of the felony defendants. Okay, also, we see that many come from broken homes, which you might imagine. It's not just that they will, didn't get all the training that they need and so on. They've been out in the world and there's no one there helping them. And there hasn't been for a very long portion of their lives. And so they're sort of out there helping themselves kind of thing. So you can see that a lot of these would just lead to an additional incentive to do crime rather than get money legitimately. But other ones, you wonder what's going on with some of this stuff. Because, the racial minorities that are disproportionate are, of course, black, Hispanic, and Native American. All right, let's look at the center of the courtroom drama. Let's look at so let's think of this in drama in the sense that we have typically a poor or, let's say, economically challenged defendant. They are undereducated. They really don't know very much about what's going on. They don't know how to deal with it, certainly. They're ill-equipped to deal with the court for many other reasons. They don't know why the law, not to say why the law is what it is, but they don't know all the procedure that goes on. They don't even know what to tell their attorney about what might be good for their case and so on. And mental competence is a concern with many of these people. And some of them could be insane or could have been insane at the time of the crime, including a murder type of crime. And they're entitled to a finding of not guilty by reason of insanity if they were in fact insane at the time of the crime. And so, what do we do with these people? Do we give them, a competent psychiatrist to examine them and testify for them if they were in fact insane at the time of the crime? Well, the Ake case was a good example of this. This is where a very, mentally ill defendant was brought into the court to be arraigned on a murder case, and he was acting so bizarrely that the court actually had him examined by a psychiatrist to see if he was even competent to stand trial at all. He was found incompetent. He was then placed in a mental institute and given antipsychotic drugs, and then declared to be competent. He was then tried, but the public defender for him asked for, at state expense, a psychiatrist to testify as to whether he was insane at the time of the act. The court system in the state refused. The United States Supreme Court got their hands on it and said, no, sorry, you're going to have to give them a free psychiatrist because it's part of their defense. It's something that without that, you can see these people would just be railroaded right through the system. They'd be found guilty of a crime that technically, not technically, but in fact are not guilty of, because you're not guilty of even a murder if you are insane at the time of doing the murder. You may be put in a mental institute for being insane, but you won't be put in prison for it. So let's look at the pro se or improper type situations as well. What that is when a defendant, despite the fact that the court will give them an attorney for free, wants to represent themselves in their own criminal case. So the rules that have been coming out on the Ferretta case and the Indiana versus Edwards case are that first, so long as the defendant is considered to be at least reasonably mentally competent, meaning they're not, a complete nutcase that will do something really crazy, and they seem rational, they're going to be allowed to represent themselves. And a court may, if they want to, appoint standby, what's sometimes called shadow counsel, to be there, knowing all about the case, knowing exactly what to do, to answer any questions, to even jump in and become counsel for the defendant if the defendant feels later on they need to have an attorney. Okay, so the pitfalls of social media for the defendants is quite remarkable. As we all know, defendants have the right against self-incrimination. However, they will stupidly put on their social media accounts information about what they're doing or what they think, and even about what they think or what they're doing in connection with their case. And so the People versus Minkard case was kind of famous because in that case, a lady was, a DUI. She ended up killing some people. There was a recommendation just to county jail, not state prison, because it was, not, although it was an aggravated case because it killed people, that's the kind of thing that can happen to anybody if they're in the wrong place at the wrong time, and they are also DUI. The judge then ended up giving her a 64-month sentence to state prison when they found out at her social media account she had a picture of herself drinking after the trial, drinking with some friends, and had a t-shirt on that said, "I love Patron." And that was it. So she convicted herself. She sentenced herself on that one. So you can see, you got to be very, very careful. And this, by the way, is also a pitfall for police officers who we sometimes find make the same mistake and say things or do things on social media that are discoverable and can end up, showing that they were lying on the stand. It can, or that they were misleading things, or that they were biased against a certain type of defendant or type of crime, whatever it may be. So these are kind of things you got to be very, very careful of. All right, so let's look at courts controversy and racial discrimination. So the question you might want to ask is, can Latinos get equal justice under the law? Do you believe that Latinos experience discrimination in the court system? Well, in California, we have a lot of Latinos, and we also see a disproportionate number of Latinos in the criminal justice system as defendants. And so the question becomes, is there in fact discrimination in the court system? Frankly, I have not really seen it. Not that I can put my finger on. There may be some people who have it in the back of their mind, and it may have and be involved in some of their decisions, even judges possibly, but it's not something that's easy to see in my own experience. So, but let's think about what your experience would be, or what you might think, because I'm sure that some of it's going on, but I just had never seen it out in front where people can see it and is exposed to people, so to speak. So we might also ask the question, how might socioeconomic status impact treatment in the court system? If you are poor, do you get a different shake in the criminal justice system? Well, look at the opposite situation. What they said about O.J. Simpson and why he got off on the criminal case was that he was a rich, famous celebrity. Okay, now that's the opposite side of the socioeconomic status. Rich, celebrity, well-liked type, athletic type, all this sort of stuff. Now, had that been someone who was poor, didn't have any likability, like O.J. had, didn't have money, didn't have status, didn't have celebrity status, would that person have been convicted in that trial? Boy, I'm pretty much of the opinion they would have. And so I do think social economic status does make a difference, but it doesn't make a difference as you might imagine. What I have seen is that people who are of a higher socioeconomic status tend to get off of charges. Juries just give them a break, whereas they don't give a break to someone who's just poor and is just a nobody, so to speak. That's been my experience. All right, let's look at the courts through the eyes of the victims and the witnesses. Traditionally, victims and witnesses are lost or forgotten in criminal trials. That is true, and it has been true was true for many, many decades and quite a bit of the 20th century. There's been a lot of research done on defendants because we want to know why they commit crimes, but very little research is done on victims or witnesses to help them. This is all true. There has been a movement afoot, however, not as much for witnesses, much more for victims, but for victims' bills of rights. So in California, we had a Victims' Bill of Rights that was passed in 1982, and it definitely made all sorts of things now a right of the victim. The victims have a right to speak at sentencing. They have a right to a restitution judgment against the defendant, civil judgment against them for all the out-of-pocket losses that have been occasioned by the committing of the crime. And more recently, they have also been given the right to be informed when the perpetrator of a violent crime is going to be getting out of prison. And so lots of things are starting to be going in the direction of victims. And by the way, it's also up to the prosecutor to not represent the victim, but to assist the victim in getting those things done. All right, frustrations in coping with the process. First, this is both true as to the victim and the witnesses, but there are many trial delays. And the more serious the case, the more likely there will be delays. And it's not because the victims or the witnesses want it delayed. It's because the defendant and their attorney typically want it delayed. It's not usually the prosecutor, because prosecutors usually will not file the case until it's ready to go. And so they're essentially ready to go. It was a little bit of an exception on the OJ case for reasons that couldn't be helped. But it's really the defendant and counsel, and it's also the judge, because the judge doesn't mind delaying big trials like this, because they're hoping that if they delay it, maybe it'll get resolved without a trial. There's lots of other reasons. They're trying to manage their caseload, and if you want to delay a trial, fine. I've got more than enough trials to do, not a problem. There's also long waits when you're waiting to actually testify, either as a victim or as a witness. You may wait all day, and you're not called. You're not called even for 2 or 3 days. Sometimes you'll wait all day for 2 or 3 days before you actually are called in a major case. You can lose wages and lose all sorts of opportunities. You really technically can't lose your job, although it'll probably happen in many cases. You're not supposed to, if you're subpoenaed as a witness in a case, you're not supposed to have your job taken away from you. They do not have to pay you, but they do have to keep your job open for you, at least in California. There's also a fear of the defendant and the defendant's associates. That's another problem, both as to witnesses and the victim. There's a sense of indifference on the part of the criminal justice personnel, at least in the minds of the victims and the witnesses. The indifference, by the way, is real. There is indifference, and the reason is that, oh, you're just another sexual assault victim. Okay, well, we've seen many of them. That's all we see all day. This is sort of the idea that you get from the criminal justice personnel, and so they don't have sympathy, because if they did, they probably would be wringing out tears all day for all the bad things that have happened to people. And they just can't do that, because they have to do their job, and they have to get immune from all the bad things that have happened. So you can kind of see it from both sides of the coin there. Victims and witnesses, wonder why there's such indifference to their major calamity in their life, and the people who are in the criminal justice personnel type people, they for very good reason have to be indifferent. All right, the travails of testifying. Witnesses must speak forcefully but not belligerently. That means they have to sort of stand up for the truth, or the truth might get sort of squashed. If you're not, if you can let a defense attorney talk you into being a little unsure of what really happened, but you know what happened, you're going to end up having the jury wonder if you're telling the truth. So they have to speak forcefully in the terms of standing up for the truth, but they can't be belligerent, because then their credibility will also suffer, because juries don't like to see people who are belligerent with defense attorneys. They like to see them actually being helpful, in the sense of just wanting to get the truth out, that kind of thing. Witnesses should try to avoid being rattled on cross-examination, because what that means is being rattled on cross-examination would tend to indicate that you're making something up, that you're saying something that isn't quite true, or maybe just completely false. And we really don't want that. So we try to get witnesses to be in the frame of mind of, help the defense attorney to find the truth, just like you helped me, the prosecutor, to find the truth. And it'll be a self-calming phenomena. You know, you'll be more calm. You won't get rattled because you're telling the truth. If someone doesn't believe you, well, just say, "I'm sorry you don't believe me, but that's the truth." That kind of thing. Rape victims are put on trial, by the way. They feel even more victimized when testifying than they were by the rape itself, because they're being cross-examined, and to be cross-examined is to be examined by someone who is trying to communicate to the jury that you're lying. It never happened, or it didn't happen the way you said it happened. However, victims still express a surprising amount of support of the system, even though all these things happen to them. Okay, and in reality, the only way they will get justice is probably through the system. They're not going to be able to do it themselves, and they know it. Victims and witnesses still express overall support for the process. Less than 15% say they're dissatisfied with what happened, and I guess they just understand it's not going to be an easy process. We've got to get the truth out. We've got to get people to believe that it is the truth, and then convict someone so we can do something with them. All right, witnesses through the eyes of the court. Okay, that's the actual judge. First, there's there is a lack of cooperation by those who witness crime. They typically will not report that to the police. They will not report that a crime is taking place. There is this, this we call black number of black quantity of crime that the FBI has investigated pretty thoroughly, and it's definitely there. And it's an idea that they don't want to get involved, because if they get involved, they're going to have to testify. Maybe some of the associates of the defendant will come up and beat them up, or worse, and so they tend to want to just walk away, unfortunately. There's also witness intimidation that does occur, and there's this, the old saying, "Snitches get stitches" is a good one, because that's always in the back of a witness's mind. They can be pressured not to testify, and in some instances they can be intimidated, so they end up giving false testimony during their testimony. And this happens a lot in domestic violence cases, as you might imagine. The husband is now, putting pressure on the wife to change her story. In fact, as a prosecutor, in only one case did I have a witness, a victim witness in a domestic violence case, actually tell the truth on the stand. In every other case, it was absolutely false. And I was able to convict the defendant anyway. But I guess because we got a lot of good corroborative evidence as to what really happened. Now, social media and victims is the same sort of problem we would have social media and defendants. Victims will sometimes put things into social media that will then end up being used against them at trial. If it's out there and available, guarantee the investigator for the defense attorney is going to find it. If they're even minimally diligent, and it's gonna backfire on them. This happens with police officers as well. So don't think that this is just to people who sort of aren't thinking. Police officers should know. They've seen it happen so many times to victims and witnesses and so on, and defendants in the system. You'd think they would never write anything down that they did not want brought up on the front page of the paper, but sometimes they do it. All right, victims through the eyes of the court. Characteristics of the Victim Impact Act treatment. First, the older white male employed victims are handled differently to that of the young non-white, divorced, or never married, uneducated, low-income, unemployed male. And I just have a theory that the reason why that's true is that the older white male employed victims are people who, if one of those speaks up, people are going to listen. Whereas the one that is young, non-white, divorced, or never married, uneducated, low-income, unemployed, and a male, those people, if they say something bad about the system, nobody cares. And so I think that's the difference between why the treatment of victims is different, frankly, and so it's political in that sense, very much so. And that's unfortunate. But it is part of any system. It's the same thing that juries do and did in the O.J. Simpson case. A celebrity, rich, successful person is going to be looked on much differently than a young, unmarried, uneducated, low-income, unemployed male, no matter what. All right. Also, prior relationships between victims and defendants are common Roughly half of the violent crimes are committed by victims' relatives, friends, or acquaintances. And so we've got that kind of a situation as well as part of this process. It makes it very, very difficult. There's all sorts of things going on, all sorts of reasons why people might make something up, and so on and so forth. Let's look at intimate partner violence. Women are more likely victimized by intimate partners. There's a growing awareness that at least over the last 40 years, that this is going on. Therefore, a decline in victimization has occurred. Police are encouraged to make more arrests, even without the victim's cooperation often. Prosecutors are pushing domestic violence cases, especially after the O.J. case went the way it did. Arrests do not always lead to prosecution because victims change their minds, or there may not be enough corroborative evidence because we assume that the victim will change their mind in intimate partner violence, especially domestic violence. We now can and do get temporary protective orders to keep the defendant away from their partner, at least through the end of the proceedings on the criminal case. And those are often done on the night of the event. The order is given to the defendant. If you were to break that order, he'd be brought in on more felony charges for breaking the order, and he would not be let out of custody the second time. Okay, let's look close up. Thurman versus Torrington. This was an extremely aggravated case, and by the way, based on the time that it happened, there was probably no law against terrorist threats. There is in California and in many other states now that is a felony, and it's also a strike. And police take those very seriously now, at least in California. But back then, what was happening is this was an estranged husband who was threatening to kill Tracy and her son. That was his son as well, by the way. She kept going after the police to get them to arrest him, and never really could. And she's actually being threatened in front of a police officer on one occasion while she's in her car, and they don't do anything, literally anything, until he breaks the windshield, and then they arrest him for breach of the peace, which is a misdemeanor, I guess, for making a lot of noise. He gets out, goes after her again. She calls the police. He's out there, outside the house, threatening her and trying to get in and so on. The cops finally come out, watch, the husband outside the house. Tracy, then she comes out of the house to try to convince him not to hurt the son. She's stabbed multiple times. She's already called the police. The police are not quite there yet. They get there after she's been stabbed. She's on the ground. He has a bloody knife in his hand. Still, the police don't arrest him or do anything. And as they're coming up to the scene of it and seeing what was happening, the husband kicks this woman in the head and runs in the house. He comes out with the son in his arms, throws the son on top of the mother, kicks her again. Still, the cops don't do anything. Finally, at some point along the line, she's arrested. She survived the attack, which is funny because she should have died. She had something like 13 stab wounds, but she was badly hurt. She sued the city's officials for not intervening to protect her, and she wins, and she should. That just, I can't quite understand that one. But that was all during a time when people, or these police, were thinking of this domestic violence as being sort of, a family affair. But here's the woman's stabbed, probably to death, right in front of the officer, and he's doing nothing. It's insane. But anyway, this is a good case to see why it is that the states needed to revise their domestic violence laws, including mandatory arrests of suspects, because this is the kind of thing that happens if you don't intervene to stop the violence. He meant to kill her. He would have to stab her 13 times. What do you think is going to happen when you stab someone 13 times? Anyway, so you can see now why mandatory arrests are almost universal throughout the United States, all the states, and for domestic violence of some sort. So, and it's just all you have to do is identify someone has been involved in a domestic violence incident, at least probable cause to believe that they were the perpetrator, and they're arrested by law. They must be by law now. Okay, let's look at aiding victims and witnesses. So there's been some key developments, especially over the last, since the early 1980s, at least in California. First, victims and witnesses assistance programs. And what these are people who actually will go out of their way to help witnesses, get transportation to the court system, to get food while they're there, when they're waiting around. They'll make appointments to meet with prosecutors so they can be interviewed. And this is true for victims and witnesses. And the victims will actually get assistance, which includes medical bills being paid, psychiatric care being paid for, and some out-of-pocket losses that are caused by the crime are recompensed by these victim witness assistance programs. And by the way, in most cases, they're funded by the fines that are paid by criminal defendants, so it's a very interesting process. The perpetrators basically end up paying for the victim assistance. There's also a victims compensation program. That's what I was just talking about, is compensation programs. But victim witness assistance programs, where we assist the victims and witnesses getting to court and dealing with the problems of just being a victim and a witness that otherwise would never have been helped. There's also victims' bills of rights, which actually gives legal rights to victims for certain things. I told you in California, for instance, they have a right to a restitution judgment against the perpetrator. They have rights to speak at sentencing. They have a right to be informed when the perpetrator gets out of prison in violent crimes. And so, as part of one of the rights, of course, they can make what we call victim impact statements to the court. And there's nothing you can do. I mean, as a practical matter, unless they end up being contempt of the court for some, rude or inappropriate language, they have a right to make a statement and say anything they want. It's their statement. It's their time. And normally, the time can be limited, but only if there's a good reason, and only if there's an amount of limitation that will be reasonable. Victim impact evidence and restorative justice is another issue here. In essence, restorative justice has to do with trying to make the defendant back into a law-abiding citizen. And so sometimes we use a victim impact evidence as part of this restorative justice process, and we actually get the victim sometimes together with the perpetrator. In non-violent cases, by the way, we don't do this with violent cases. But let's say a kid, ends up doing some malicious mischief, some vandalism of somebody's house. We might get the two together, and the kid might actually go and repaint the house that they had spray painted, something like that. So the effects of victim impact statement on sentences is generally dramatic, by the way. I'll tell you, it's not unusual to have these kind of statements in the middle of a packed courtroom where there's all sorts of things going on. And there's this drone of people talking. Not just the court, but attorneys talking to their clients, talking to each other. Lots of business going on in the courtroom, and it's just a drone of noise. All of a sudden, there'll be a call the case for a witness impact statement for sentencing on a certain case, and you could not hear a pin drop in that courtroom when that person starts talking about what happened to them. It is very dramatic, to say the least. All right, let's think about the thinking point regarding the Victims' Bill of Rights. Let's consider the Victims' Bill of Rights for your state. First, what does it offer to victims? It's a good idea to go look it up, because if it's like California, you can see that victims now are getting more and more rights in the system when they had none before. Again, the criminal case is not in their name or for their benefit. It's in the name of the state prosecuting someone for violating their laws, and they would have had no other rights to do anything. They, in fact, would have an obligation to come in because they're subpoenaed. That was the way it was before. Now they've got a Bill of Rights. So depending on your state, figure out what those Bill of Rights are, and you can have a pretty good idea of what your state thinks about victims and trying to help them. Also, what type of victims are protected under the Bill of Rights? Is it just violent victims, or what about economic victims where something has been stolen from them? Do they get any kind of protection under this Bill of Rights? Is it comparable to the extent of injury? In essence, is it comparable to the extent of injuries that the victim's been subject to? In essence, is the Bill of Rights, have to do with how much they've suffered? And it would be in California, for instance, you wouldn't get psychiatric care if you weren't involved in the crime. Meaning, if someone stole something from you, you're not going to get psychiatric care. But if someone beat you up, you could. So it makes a big difference. So where do victims go to receive the compensation? How do they get it? And that sort of thing. In your state, how is it funded? That's another question for you to think about. Let's look at the victim impact statements. Let's look at Payne versus Tennessee. The victim impact statements are admissible during sentencing. And so the question becomes, should juries hear about the Payne victim's experience? Well, that's a good question. They shouldn't if they're not going to be making a sentencing decision. But if they're in a murder case and they're going to decide on whether the person dies or goes life without possibility of parole, then the answer is yes. They should hear about the pain of the victims. Absolutely. Depends. So it depends on whether they're involved in sentencing or not. And in most cases, juries are not involved in sentencing. Only the judge is. But for murder cases, most states will require a unanimous verdict by the jury and affirmed by the trial court for a death penalty. All right, what help is there for the victims when the trial is over? That's another question. Well, there is in places that have victims' bills of rights, because those payments for medical bills still continue. The payments for psychological care, they continue. And sometimes for other types of losses that may have happened as a result of the crime. All right, let's look at aiding or manipulating victims. Is the victims' rights movement something that actually aids the victims, or does it manipulate victims? Because remember, if you're giving away benefits, which include money, include services of all kinds, these victims will want those services. They may want that money. And so the question becomes, yes, you're aiding them, but are you also manipulating them? Because they know that if they don't get a conviction in the court, they may not get that money, or it may not continue, depending upon how the system works. So do you think that victims benefit from all this? Is it really worth it? And or does it manipulate them? It's good questions to ask. All right, that's it for the issue of victims and witnesses and defendants. So if you have any questions regarding this matter, please feel free to give me a call, email me, or otherwise contact me, and I would be more than glad to help.